SJC-11467, Commonwealth versus Hernandez.
Mr. Mirsky, good morning.
Good morning, Your Honor. Good morning, Your Honors. I'm Attorney David Mirsky for the defendant appellant Jose Hernandez. This is an appeal from a conviction of first-degree murder by deliberate premeditation. There was a defense of self-defense, and Mr. Hernandez testified in his own defense. And there was a motion for new trial pursued in this matter. The way this involves the matter of the lack of proficiency and other problems with a crime scene evidence supervisor, Eric Kester.
Right, you just heard our last argument.
Yes.
So if you could address the Sullivan case, Mr. Mirsky, and how this is different from that.
Well, in the Sullivan case, Mr. Kester was not directly responsible for the DNA testing that implicated the defendant in the crimes. In this case, it's quite different. It's actually very focused, and it's not a matter of quantity. It's a matter of a lot of things. But there was I learned about this the day before oral argument was scheduled in May 2015, and I was talking with the trial counsel, and she mentioned that somebody had been terminated and who had been involved in the case. And I checked with Ann Goldback at CPCS, who's the director of forensic services, and I got documents from her. And what I found was it hit me like a thunderbolt because of what this case is about. Mr. Hernandez testified that he, first of all, that there was a testimony by Mr. Hernandez and Mr. Santiago that the decedent was agitated and seeking drugs and knocking on Mr. Hernandez's door and trying to get drugs and being turned away, and that there ended up being, they ended up out on the street with Mr. Hernandez standing at the passenger side window, in the front seat window, and and had a continuation of argument with Mr. Plaza, the decedent. And the issue, the central issue, I would say, at trial was whether, was Mr. Hernandez's assertion that Mr. Plaza told him, okay, I'm going to leave, but don't give me your back, because if you do, I'm going to kill you. You know what? I'm going to kill you right now. And then Mr. Hernandez testified that Mr. Plaza moved towards the passenger seat and reached for something and grabbed something. And at that moment, in a fairly reflex response of self-preservation, shot a gun that he had been given that night by Mr. Santiago. There was a big issue at trial as to whether anything was in the car at all. There's an exhibit that is extremely misleading, trial exhibit number 12, which I believe is 7778. SR supplemental record appendix at 77 to 78. And the thing that is shocking really about that picture is that it shows the car with apparently nothing on the floor and apparently nothing on the passenger side at all. And that was presented to the jury had that but there was other testimony that there were items in there. There was a cell phone, there was a steering wheel lock, a metal steering wheel lock.
I may have confused this with the other case because they both deal with the same chemist, but my memory was that the car crashes through the fence, right?
Yes.
This case, all right, the car crashes through the fence.
Right.
And the chemist is called out to the scene. He walks by the car and then leaves. He doesn't really search the car. Someone else searches the car, right?
He's the actual supervisor of evidence collection.
He's the supervisor.
And he testified in a pretty much a self-glorifying way
Okay, but
that
if you could answer my question, please.
Oh, sorry.
There was testimony that someone else was assigned to search the car, correct?
He was part of one of the people responsible, and he was the director, the supervisor of searching.
Right, who personally searched the car? Someone other than him, correct?
Yes, and it was brought to another place, and there was a group of people, and certain people said that one person said he didn't search because he didn't have a search warrant. They just looked inside, but they brought it to a yard, a towing yard, and a group of people searched, and the key thing here is that Mr. Kester testified that his job was to make sure that the evidence is being processed, collected. He said that. And he also said that he supervised a team of, his job was to supervise a team of crime scene responding forensic scientists in 3 counties on call 24 hours a day, every day.
He was a supervisor in Sullivan too, right?
In the Commonwealth versus Sullivan.
Right, he was a supervisor.
Yeah, I think so. And when a crime scene came in, he was the person who dispatched the appropriate personnel, and that if it was a complicated scene, such as a homicide, he would supervise the scene and make sure that evidence is being processed, collected. And now, at this trial, he testified on March 23rd, 2012. The trial started on March 20th, 2012. On March 9th, 2012, he got a communication from quality assurance and technical leaders at the crime lab that his proficiency exam from previous year, actually 2 previous years, had been deemed not satisfactory. His 2011 crime scene proficiency test score of satisfactory had been rescinded, and he also knew on March 9th, 2012, that his 2010 crime scene proficiency test was unsatisfactory as to his examination of angle of impact measurements. Now, the thing about Mr. Kester and why this is the whole picture needs to be looked at with Mr. Kester, and I have a lot of documentation here. He didn't just make mistakes. He didn't know what he was doing, and he also covered it up. He told people he never made that kind of mistake when he was being shown a mistake that he made. When his DNA was found on evidence, they couldn't figure out, he wouldn't help them figure out why. They couldn't get an answer out of him. When he told, when work of his was questioned by, as far as blood stains on the ceiling by an assistant district attorney, he just said it doesn't matter, he can still testify to that at trial.
So it sounds like he was not a great crime scene analyst.
Right.
Okay, but what did he do in this case? How does it matter in this case if I understand he supervised, but aren't we just talking about impeachment? If this
Well, Your Honor, the way this struck me, I didn't think of it I thought of it more as something more substantive than just that, and it's because what we're dealing with here is the credibility of Jose Hernandez testifying that something was in that car, and then we're being told by somebody who really has no credibility at all that his job is to find and process and get the evidence from the crime scene.
Better argument if he was the only one that processed the car, right?
To me, I'm looking at the credibility of the way it's used, the way this was specifically used against Mr. Hernandez. And it was,
Another witness in this trial testifies that they processed the car and the only thing they found was a cell phone in this club, right?
But those are things that we don't have, Your Honor, and those are things that the assistant district attorney felt a need to dispute that the steering wheel lock could have been an item that Mr. Hernandez thought looked kind of shiny. Okay. What we have, it's a global picture. It made me personally connect everything. There's this photo that shows an empty car, but it's not true because there was stuff in there, and we've been told that. There's evidence that's really important to look at physically and examine.
But the issue we look at in context is whether Mr. Koster's failure of some proficiency tests would have impacted the jury where he was a supervisor of the crime scene crew that looked at this car, but that was processed by the police and different crime scene analysts, right?
Well, the thing is, Your Honor, that there are procedures for what the crime scene analysts do, and as a supervisor, he's supposed to get the people below him to follow those procedures. Only the evidence shows in the motion for new trial that Mr. Kester doesn't know half the procedures and doesn't seem to care that much about procedures, and also that he has a bias in favor of finding evidence that will convict. And it's a dangerous thing for this Commonwealth to have somebody like that being responsible to collect the evidence. And not only that, to be in a courtroom at a murder trial and pumping up his own credibility when in fact he knows that his superiors are questioning his proficiency. And that's a serious thing for him. He knows it. It's a serious thing that's going to affect possibly his career, whether he has a job. It's going to affect whether he has to speak truthfully to the State Police Crime Lab, which apparently he did not. And this person infected this trial, and the least of all, and Brady and Kiles versus Whitley, which only require that you show that the evidence undermines confidence in the verdict.
Well, we've said in Sullivan it's exculpatory, and we've said in Sullivan it's admissible.
But I mean, all we're talking about is this shifts the whole balance of what is truthful and what isn't in this trial. And there was a contest between the trial counsel and, for Mr. Hernandez and the assistant district attorney over whether there was anything in that car, whether it was ridiculous to say there was anything in that car, whether it was ridiculous to claim self-defense in this manner. And the fact that this man coming down as the boss supervisor from the crime lab who supervises and makes sure the evidence is collected, the fact that that man was permitted to testify, to present that to the jury, but they weren't allowed to know that he's actually not that. He's not qualified. He's not reputable. He's not even believable, and even by his own superiors. And that's why he lost his job. I think that I can see in different instances that you could separate something about the conduct of a witness from the ultimate outcome. But here it's not going to happen because this is the whole case. It's the whole case.
Now, how can you file a supplemental brief on this issue and not cite Sullivan?
I wasn't aware of it, Your Honor. And it helps me, so I don't have a reason not to. It's actually extremely helpful.
I think that's his point.
I think the reason I didn't cite it was because it's DNA, and my case is not about that. And DNA, the particularities of whether somebody lacks proficiency or is involving DNA it's only relevant in the way that the case, I think it's Cowles, that if there's a new procedure, scientific procedure that comes along, that should be considered worthy as newly discovered evidence. But for me, it's not a DNA case, and it's not we know there's no dispute about who was there, and the question is what happened, who's telling the truth, and what those items, whether they could have been perceived as something shiny that would have scared Mr. Hernandez. And I would also add that the medical examiner found that it was certainly possible that Mr. Plaza could have been leaning forward when he was shot, and that corroborates what Mr. Hernandez said. And if that's okay, I'd like to move on to another issue.
Okay, you've got 2 minutes.
I'd like to talk about from the principal brief the trial judge excluded the question about where defendant's counsel was trying to get the witness to acknowledge that he had a great deal, and after Mr. Sinek, it's Miguel Sierra as a witness, after he had claimed that the reason he was testifying was just to help the family of the decedent, when the truth is he had an extremely good deal. He was not being charged for possession of heroin.
But didn't he just exclude characterizations of the deal? I think that he excluded, it's the deal of a lifetime.
He excluded the other one too, though, Your Honor.
I thought it was kind of a hyperbole. It was either asked or answered, or it was
It's not
adequately explored on direct or cross-examination.
It's not deal of a lifetime. It's
Well, that was one of them,
that was one. It's
that you claim that's error.
huge break.
Right.
Huge break. I
so-
think she should have been allowed to ask him that, and
But it
he
was
should
a
have,
huge break in the deal of a lifetime, as opposed to allowing in what the deal was? Right?
I think what she was doing, Your Honor, was getting him to face and to respond to what he was.
But there was cross-examination as to what the deal was, correct?
Yes,
And the defense attorney was allowed to argue to the jury that it was the deal of a lifetime and a huge break. But the witness wasn't allowed to have it characterized as a huge break or a deal of a lifetime.
the witness did not have to respond to those.
Have to agree to that, okay.
Yeah.
I believe your time is up.
Thank you, Your Honor. Thank you, Your Honors.
Ms. Smell.
Good morning, may it please the court. I'm Catherine Semmel for the Commonwealth. I will begin with Eric Kester, if that's okay. I think that Judge Feely's rulings on the motion for new trial are very helpful. They're very detailed and provide a good chronology of the kind of voluminous information that was produced. I think the bottom line is at the time of this trial, which was in late March 2009, two things had happened. He'd received two unsatisfactory results on blood spatter tests, specifically having to do with the angle of the blood spatter, how he measured it, the tool he used, but it all had to do with the angle of blood spatter evidence. And as Judge Feely wrote in denying the motion for new trial, the question really for us now is what would the defendant have gained from an impeached Eric Kester with this information? And I think Judge Feely correctly concluded that the answer is not very much. And in assessing that, I think, excuse me, there are three factors that are relevant. And one is the nature of his unsatisfactory proficiency tests. Two is his nature of his involvement in this case. And three, we learned from Sullivan, is the nature of his testimony at trial. And there's no question that there's no blood spatter evidence in this case, so that there is no direct relevance. There's no question that Mr. Kester was not directly involved in a lot of this case. He didn't search the car. The one technical analysis he did was he analyzed shirts for gunshot residue, which became a non-issue in this case because there was no question that the defendant had shot the victim. He acknowledged that he had, but did so in self-defense. And other than that, he testified generally that his job was to supervise, that he was a supervisor of the scene. Different from Sullivan, he did not give any testimony about his expertise, about his qualifications for these positions, or any of the things that in Sullivan made this court think that it was misleading not to tell the jury about his failed proficiency tests, particularly because I think in Sullivan, which the trial was a little bit later in time than this case, so at the time of Sullivan, the unsatisfactory trace evidence result had come back. And in Sullivan, Mr. Kester happened to mention that one of the things he was trained in was trace evidence. So the court pointed out that under all those circumstances, it was misleading not to tell the jury about his failures. Not the case here. And there's been some talk about the stuff that was in the car. Sorry, that's my technical legal definition of stuff. And really, there was no dispute that there was a club in the car. There was no dispute there was a cell phone in the car.
Who searched the vehicle?
There was a couple of people. Steve O'Connor, who is our CPAC detective, he's the one who testified that he testified to those items that were in the car. So he searched the car, I think, at the scene, but I'm not positive. Jim Crump, I believe his name, was a ballistics guy. He looked specifically for ballistics evidence in the car.
Kester did not.
Kessler did not. Correct. In fact, I think the defendant cross-examined him. That was one of the things he emphasized on cross-examination. So there wasn't really a dispute that those things weren't, well, there wasn't a dispute that those things were in the car. In fact, the prosecutor mentioned the club in closing and tried to argue that you couldn't mistake a club for a red shiny club for a security device for a gun. So there wasn't any dispute about that, and the defendant wasn't in any way precluded from arguing that the police should have collected those items, which they didn't.
Did they photograph them?
I'm sorry?
Do they photograph everything in the vehicle?
I don't think there are numerous photographs besides, I think only one was introduced at trial. There are other photographs of the car, but I didn't see any that depict the club in particular. And I'm not sure if it's the angle or why that was. But I think it is also true that if
But he was shot in the car,
correct.
and they didn't take extensive photographs of
They
the car?
did take photographs, and for some,
Is that unusual?
I
They take photographs of everything.
yeah, and there are numerous photographs, and I'm not sure, I don't have an explanation. As I said, only one was introduced, I believe, but even the other ones that I've seen don't seem to depict that, and I'm not sure why. I'm not sure why that is. I do know that at the time that this happened, the police didn't even know where he'd been shot. There was no evidence about this case, basically, linking it to the defendant or what specifically happened until 5 to 6 months later when Miguel Sierra and Santiago came forward.
So they didn't know he was shot in the car?
He could have gotten into the car. I mean, he was driving the car when, away from the scene.
Right, and he collapses in the car, right? He never left the car, right?
Correct.
Okay.
Correct, but they didn't have any person to testify to what happened before he crashed the car.
So there were no photographs at all of the club? How do we know what the club looked like?
The CPAC detective testified that it was a red security device.
It was a
Club.
red security device?
It was a red
Like
club.
one of those steering wheel things?
Yes, I'm sure he described it better than I did. Yes.
We have only the color. Do we have anything as to its shininess?
I don't remember how else he described it.
In that trial, did the defense attorney make or exploit the lack of evidence of what was inside the vehicle to bolster his
Yes.
self-defense claim?
Yes, he did. He used it to float, in closing, he used it to float the idea, well, if they didn't collect these things, maybe they missed a gun, was basically his theory.
And the defense attorney, I assume, was incredulous that they didn't photograph the vehicle as we are now?
I can't comment on that, I'm sorry, I'm not sure. And possibly there are photos that I haven't seen, but I have not personally seen any that depict that. But it wasn't disputed at trial that they existed, and our detective testified that they did.
Wait, now Mr. Mirsky mentioned the photos at SR 77 and 78, which are hard, I can see them in black and white. Do we have the color photos
Yes,
in evidence? That's Exhibit 12.
I believe so, and if not, we could certainly.
And do those not show the club?
I don't believe they show the club, no.
And so how can they have a photograph of the interior of the vehicle which does not show the club?
I don't know, Your Honor.
So there were photographs taken at some point in time.
Yes, they were. Yes, they were. I'm not sure if it's the angle they were taken at. I think that Detective O'Connor testified that they were on the floor, that the club was on the floor. I think they were taken mainly from one side of the vehicle.
Right, so we have one photograph of the passenger side that has the door closed, and then we have a second photograph of the driver's side that has the door open.
From the driver's side angle, yeah, so it's possible that you can't see things on the passenger side floor from
Is
there.
it that there were other pictures, they just weren't offered?
There are other pictures, but I'm not sure that they capture the club. I don't remember seeing them.
But either way, to get back to, I guess, to the issue, but Coaster had nothing to do with this performance, this documentation of what's in the car.
Correct. Yes, absolutely. And I would say this case is is unlike Sullivan in terms of the relevance of the proficiency tests, given the nature of the involvement in Kester's testimony. But like Sullivan, in terms of the lack of prejudice in this case, because the defendant was not precluded from arguing anything about the collection, and none of the proficiency issues went to anything remotely relevant to what Kester did or what he testified to at this trial. I would be happy to discuss any issues, other issues that the court has. I would be guided by you if you have questions about any of the other issues instead of just going through them.
Thank you.
Okay, thank you.
All right, and we would just ask the court not to exercise its authority under 33E, given the lack of special circumstances. Thank you.